A game of Russian roulette ends in a shooting death. Police locate Mr. Davis, who they believed was a witness to the incident. They go to his apartment, but he's not there. Instead, they're met by a roommate who consents and gives authority to the officers to enter the apartment and search the entire place. They go to Mr. Davis's bedroom. There, under his bed, they locate a gym bag, they open it up, and they find a shotgun inside. Mr. Davis is charged in federal court being a felon in possession of a firearm in violation of 922G. Now, if you're currently thinking, can police officers really go without a warrant and search the apartment just because your roommate authorized them to do so? Well, you're on the right track. So today we're going to talk about actual and apparent authority to consent, and the overall theme of the case will be reasonable expectation of privacy. My name is Anton Welch. I'm a criminal defense attorney in the Southern District of California here in San Diego. If you're new to the channel, welcome. Hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to lawstash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, stickers, and some other items. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Welch discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we're discussing a Ninth Circuit case, United States versus Davis. Now, in the introduction, I gave you some of the background about the case, but let's fill in the gaps. Of course, you already know that there was a death. Officers are investigating it. They believe that Mr. Davis was a witness to this death. They locate Mr. Davis's girlfriend, Miss McMains. They go to her workplace, and they question her about the whereabouts of Mr. Davis. She tells the officers she has no idea where he's at. She lies. She knows exactly where he's at because they live together. When the officers leave, Miss McMains immediately calls her roommate, Miss Smith, and tells her the officers are on the way. Do not open the door. Now, Miss McMains was correct. The officers did in fact go to the apartment. They knocked on the door. Miss Smith answered, but she consented to the search of the entire apartment. And she even provided a copy of a lease which had two signatures on it, Miss Smith and Miss McMains. One signature that was missing is Mr. Davis. He never signed to the lease. This was a 2-bedroom apartment. Miss Smith slept in one bedroom and Miss McMains slept in the other, but she had Mr. Davis also staying in the same room. The officers went into the room that they believed Mr. Davis was sleeping in. They opened the door. They looked under his bed. There, they saw a gym bag. They opened it up and found a shotgun. They seized the shotgun and left a card instructing Mr. Davis to call the detective or simply go to the station. About 4 hours later, Mr. Davis went to the station. He was not arrested. He was not provided Miranda rights. Instead, he was questioned about the firearms, and he admitted that he was in fact a felon and he was not supposed to have this firearm. Mr. Davis is charged with being a felon in possession of a firearm in violation of 18 U.S.C. 922G. He later files a motion to suppress and says that the officers should have never went into the apartment and searched his bedroom and specifically his bag. Now, before we talk about the Fourth Amendment, remember, the Fourth Amendment protects people, not places, meaning that Mr. Davis has to demonstrate that he has a legitimate expectation of privacy in the place to be searched and the items to be seized. But it is well established. If you've been paying attention to my channel, you already know this, that being an overnight guest in an apartment or a house gives an individual a legitimate expectation of privacy in that place. The government here argues that because Mr. Davis was not on the lease and was not permanently living in this apartment, he didn't have an expectation of privacy. But again, we know the fact that the individual being an overnight guest has the same rights as an individual who's permanently living there. Moreover, here Mr. Davis has an expectation of privacy in his gym bag. Here's another point. When we're talking about expectation of privacy, even if Mr. Davis did not have expectation of privacy in the whole apartment like he did, an individual retains his interest in his private property, like closed containers, even if that closed container is located in the property where he doesn't have full control over. For example, even if you leave a closed container, like a gym bag, in somebody else's apartment, you do not give up your expectation of privacy in those items. So an individual there still cannot open the bag, whether it is a private individual or the police, without a warrant. If we're talking about police, of course, we're always talking about warrants. In terms of private actors, it is completely different. But in the criminal sense, we're dealing with the police. And leaving your gym bag in somebody else's apartment, you still retain your expectation of privacy. And here, the government and the court says one more thing. The court says the fact that Mr. Davis hid his bag under the bed even more manifests the fact that he was trying to keep his bag and personal belongings away from public view. So here, Mr. Davis did in fact have a legitimate expectation of privacy in his closed container, namely the gym bag. The Ninth Circuit concludes that if the Fourth Amendment does not protect Davis's expectation of privacy in the contents of his bag stored under the bed in an apartment where he sleeps and keeps his belongings, we find it difficult to imagine what the Fourth Amendment does protect. Having determined that Davis had a legitimate expectation of privacy in his gym bag, the next question becomes, can a third party, Ms. Smith, consent to the search of that gym bag? Whenever we talk about third-party consent, we're always talking about two types of consent. It could either be actual consent or apparent consent. So let's begin with actual consent. A third party has actual authority to consent to a search of a container if the owner of the container has expressly authorized the third party to give consent, or if the third party has mutual use of the container and joint access to or control over the container. In 1993, United States versus Welch, the Ninth Circuit held that a person cannot give the police permission to search someone else's purse even if the purse is located in a car over which both persons have control. The shared control of a host property does not serve to forfeit the expectation of privacy in the containers within that property. In this case, there is nothing on the record to suggest that Ms. Smith had a mutual use and joint control or access to Mr. Davis's bag. It is clear that Ms. Smith did not have actual authority to consent to the search of that bag. So now let's move on and talk about apparent authority. Under the apparent authority doctrine, a search is valid if the government proves that the officers who conducted it reasonably believed that the person from whom they obtained the consent had an actual authority to grant that consent. As the label apparent authority suggests, it's all about appearances. Does it look like the person can consent to a search of the place? Well, here the government argues that when the officers approached the apartment, it looked like Miss Smith could consent to the search of the entire apartment. She even provided a copy of the lease. Her signature was on it, and it looked like she lived there and she had the lease and she could consent to the search of the entire apartment. But the court says, not so fast. Here we're not talking about the entire apartment. We're more interested whether Ms. Smith had apparent authority to consent to the search of the gym bag. And the court says that in this case, it doesn't appear so. The officers knew that Ms. Smith slept in one bedroom while Mr. Davis slept in the other. It doesn't look like Smith had control over both bedrooms, and it also didn't look like Smith would ever go in the other bedroom, especially under the bed, to inspect the gym bag. It doesn't seem like she had apparent authority over the bag. And for that reason, the court says this is not a valid search because the consent is not valid. It is an illegal search in violation of the Fourth Amendment. Remember, the Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search. Here, of course, the officers did not have a warrant. They relied on consent as an exception to the warrant requirement, and here there was no express consent, actual consent, and there was not apparent consent either. If you learned something about the Fourth Amendment today, if you now understand how the consent operates when there are multiple roommates in an apartment, I hope you click like, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and other items. Thanks for watching. See you next Wednesday.